So we've finished the discussion of my work in the domain of material culture studies, or culture and consumption. What I'd like to turn to now is some of the work that I've been doing in legal anthropology, or law and society. And as I mentioned, one of the things I found while I was in law school was that I couldn't get anthropology out of my head. And therefore, while I should have just been studying constitutional law, property law, contract law, and so forth, what I did was actually investigate those areas from a cultural anthropological perspective. So, I did an anthropology of law. I didn't just study law. And one of the manifestations of that interest in that study was a series of papers I wrote, which are available on a website called Canadian Icon. And on that website, what I do is present a series of case studies in which I use the US Constitution and the Canadian Constitution as a key for the interpretation of popular culture, from painting to pop songs in the US and Canada. So the idea was that the Constitution mediates our perception and representation of the cosmos. Okay? Very Durkheimian, very, very Durkheimian. But the idea was that just as in primitive classification, Durkheim and Mauss suggested that the form of society provides the model for the way in which the cosmos is conceptualized, I sort of took the Constitution as the key and argued that it mediates the larger reality. So I can't go into all the studies that I presented on that website. You're welcome to look at it, but just two examples might suffice. I remember, while I was in law school, it was in 1984, these songs in aid of famine relief for Ethiopia became very, very big, 1984. And there was the British song, which, Do They Know It's Christmas? There was the American song, We Are the World. There was the Canadian song, Tears Are Not Enough. So what I did was look at the lyrics of these songs as constitutional discourse. And it was amazing how they opened up to being interpreted through this lens. We Are the World is a direct extrapolation from we the people of the United States in order to form a more perfect union and secure the blessings of posterity. We the people becomes we are the world. And the kind of sureness with which the American song affirms, we are the ones who make a brighter day, so let's start giving, is remarkable. Compare the Canadian song, and my argument was that, the Canadian Constitution poses a unity of you and I, not a unity of we, okay? That the American idea of a we, just as the American idea of an individual, is very, very strong. In Canada, you don't have that same idea of individualism. Okay, so American individualism, that makes sense. Canadian individualism does not. And you don't have the same nationalism either, because Canadian nationalism is offset by Quebecois nationalism, for example. So in Canada, you have a fractured we. And indeed, in the Canadian song by Bryan Adams and Jim Valence and Rachel Paymont, whenever you come across the word we, you find it being well, they have to explain, okay? And so, as an example, one of the lines from Tears Are Not Enough, and if we should try, it's as if somebody asked them, well, who do you mean by we? And they go on, together you and I, maybe we could understand the reason why, okay? And so, the idea of a unity of we isn't apparent in the Canadian setting. And the Canadian song also has 2 lines in French, because you can't address the world in just one language, okay? You have to have 2 languages to be intelligible. And so there were all these features to the songs that I related to the Constitution. It was, I thought, deeply revealing. I could have been hearing things, I could have been seeing things. It was obvious I couldn't get anthropology out of my head. I was now using the Constitution as, in a Durkheimian and Mauss fashion, to interpret these productions of popular culture. It was a fascinating exercise. I also analyzed the paintings of Norman Rockwell and Alex Colville, the poems of Margaret Atwood and Walt Whitman, and a number of other examples, the performances of Glenn Gould, and then Van Cliburn. In each case, trying to figure out these iconic figures, what made them iconic? And my argument was that it was their constitution. Most sociologists would not look to law, which is part of the superstructure, for a model for how to interpret society. But I was engaged in the study of a superstructure, namely law school, and so I used this as a model for understanding in a slightly different fashion what these 2 cultures, how there was a system to their differences. So that was one way in which I diverted myself during law school and entertained myself, because law school can be boring. But then, it came to as well, what can anthropology bring to law? And let me just say from the outset that I think there should be an anthropologist in every law firm and in every courtroom. Okay, I think that much as in the case of medical anthropology, you find that anthropology has had a vital role to play in helping physicians interpret the expression of symptoms and making health services culturally relevant. I would argue that there's just as important a role in the field of law for the legal anthropologist to play. And so, my basic claim is that really this terrain of legal anthropology needs to be enlarged significantly, and we need to bring a cultural approach to bear on the law. So one of the things that I've elaborated in that context is a paradigm that I call cross-cultural jurisprudence. Okay, so formerly I talked about cross-cultural consumption. Now it's the idea of cross-cultural jurisprudence. And the idea is that, when the parties to a litigation belong to minority cultures, or one to a minority culture and another to the majority culture, then judges ought to take their background, of the litigants into account, that justice should not be blind to cultural difference. Rather, because cultural difference is what makes us human, justice should be administered in a culturally sensitive and culturally reflexive way. So this has been, the argument that I've been elaborating over a number of different publications, most notably a special issue of the Canadian Journal of Law and Society called Sensational Jurisprudence. But let me just give you a few examples of the kinds of issues that this raises. One is a case, this is actually from London, in which a woman, mother of 2 adolescent boys, who was from Nigeria and Yoruba in origin, living in London, is worried about her boys running with the wrong crowd. She wants to reclaim them. She wants to bring them back within their heritage. And so on a New Year's Eve, she cuts marks in their cheeks, like the tribal markings for which the Yoruba are known. She's brought up on a charge of assault, and causing injury to the boys. And this is a fascinating case of, well, what kind of sensibility do you bring to this kind of situation? She was trying to rescue her boys from going bad, and she resorts to this practice of cicatrization to do so. She runs afoul of the law for having committed an assault. Should she be held responsible? And this is a very complicated case because actually, she does this on a New Year's Eve, not in the context of an initiation ritual. And she does it with a razor, not the blade that the cicatrizer, would properly use. So the cultural tradition, and she comes from, a major city in Nigeria, not from one of the hinterlands, and tribal marking is not practiced in the metropolis. So the cultural roots of this practice are suspect, are attenuated, and yet I think you have to bring sort of a cultural lens to bear on the interpretation of her behavior. In a way, a cultural defense was being argued. My culture made me do it. And yes, it made her do it, but it was in an attempt to reclaim her sons from running with the wrong crowd. So I think it's not just the law on the books, but also in this case, the legal customs of the Yoruba that need to be taken into account. And above all, judges, I think, need to suspend judgment and look at the law from both sides, from the common law and the uncommon law, official and unofficial, in order to arrive at a proper resolution of this case. Another case, one that originated here in Montreal and was appealed all the way to the Supreme Court of Canada, is the Multani decision, a very interesting and important decision of the Supreme Court of Canada. This goes back to the 80s. And it had to do with a boy in a public school, a Sikh boy, and the question of the kirpan. And as you know, the kirpan is a symbolic dagger, although it's not really appropriate to call it a dagger or a knife. And it's the responsibility of Sikhs to wear it on their person at all times. And the question became one of, well, you can't bring a knife on school grounds, but an accommodation was made. And it was that the boy would wear the kirpan under wraps and concealed. And in that regard, it's not as though you could whip it out in any way, inflict any kind of harm on people. But the school board said no. You can't have knives at school, and therefore, an outright ban. And the boy was therefore prevented from going to school, because of his religion. And there shouldn't be an opposition, between having an education and belonging to one's religion. So the Supreme Court, looked at this, and it noted that there are limits on the right to freedom of religion. And those have to be reasonable and justifiable. So you can limit, religious comportments, but it has to be in a reasonable fashion. And the court concluded that this was not reasonable, the outright ban. The accommodation was reasonable and would have enabled everyone to proceed. And the court further held that the school had a duty to sort of give expression to the multicultural values of Canadian society by saying, we do not outlaw this religious symbol, and it's not a knife. Okay, so there's Johnny saying, but he can bring a knife, how come I can't? Okay, and the court instructs the school to say, no, Johnny, listen, this is not the case. This is not a knife. Okay, this is an integral symbol of a religion. It's like, if anything, the mace in the House of Commons. Now, the mace, which we bring in at the beginning of each session, is a medieval battle axe. And no doubt, you could use it to hit somebody over the head, but it's not a weapon, okay? And it's more than a medieval battle axe. And it's understanding, that other dimension that needed to be sort of instilled in the children at the school. So again, it would have sent the wrong message to say that the Sikh religion is not worthy of the same respect as other religions in Canada because it's supposedly violence. Look, people wear knives. And in fact, the court pointed out that there are many objects in schools, like, for example, pencils and compasses and rulers and baseball bats, that can inflict far more damage and have than any kirpan. In fact, there was no recorded instance of a kirpan having been used in any kind of aggressive manner in the whole history of Canadian education. I thought that was a very enlightened decision, okay? I thought that was the court, sort of saying, holding up this cultural symbol and saying, we have to understand that there are two views of what this object is. The Sikh view and the view of it as a knife, which young Johnny holds. And we have to actually inculcate the value and the respect for living in a multicultural society that understanding it in this different way would allow. One last case of cross-cultural jurisprudence that I found especially fascinating and that I continue to work on is the Delgamuukw decision in British Columbia. And that, as I'm sure you are aware, was a very important case, again from the mid-1980s, where the Wetswu'weten and Gitskan brought an action against the Attorney General of Canada, declaring ownership and jurisdiction over their traditional territories in the interior of BC. Okay, so instead of going the normal route, which was to go before a commission that would hear their land, they go to the court and they argue that we have ownership and jurisdiction. It was risky, very, very risky, and they brought tons of evidence in support of the idea that they have title, and that title had never been extinguished. Antonia Mills, was one of the anthropologists that they enlisted to help them make the case before the BC Supreme Court, she actually wrote a book based on her report called Eagle Down is Our Law. And what she found, what she recorded, was how the Wetswu'weten actually have what they call the law of the feast. And the feast hall, which is where potlatches take place, it's actually the place where they would resolve any boundary disputes. And then, following the resolution of the dispute, there'd be a gifting, as at a potlatch, and the matter would be settled. And so, she records, and the hereditary chiefs of the Wetswu'weten, came and spoke before Justice McEachern for hours and hours and hours about this institution they had, the feast, and the way in which it was a kind of registry office, okay, because title was vetted each time one of these feasts was held. And indeed, it was continuously up to date, but it didn't have any title, didn't have any deed. Okay? And in that regard, McEachern, the judge in the Supreme Court of British Columbia, said, this is all self-serving testimony by the chiefs. Okay, it's mythical, first of all, it's not historical. And he put more credence in the reports of Hudson Bay Company traders in the area than he did in this living testimony about an oral tradition on the part of the chiefs. So he didn't listen to them in the end. He didn't hear this idea that there can be an oral tradition which is just as rigorous as a system of title deeds in terms of the way in which each claim to ownership is vetted and which has this history. So the case was dismissed. They said, that they, based on the reports of these traders, the idea was that they didn't have sufficient organization at the time to actually, exercise ownership and control over the property. Well, it was appealed to the Court of Appeal and again to the Supreme Court of Canada. And in the Supreme Court of Canada, and again, what I think is a very enlightened decision, the Justice Lamer said that actually what we need to do here is adapt the laws of evidence to accommodate Aboriginal oral testimony. So we don't just listen and pay heed to written documents. We need to figure out a way to put oral testimony, oral history on a par with written documents. And only in this way will we, arrive at, a just adjudication of disputes. So, the court opened its ears to another tradition. The court didn't just look to written documents and having it in writing. It explored the dynamic tradition of oral history, and in effect, I think, arrived at a brilliant decision. It's backtracked somewhat since then. So in some of my latest writing, I'm pushing, along with others, to try and expand, open the ears of the court again. But that was a signal moment in terms of cross-cultural jurisprudence, recognizing that the way the feast works is outside of the official law, but is a legal tradition, nevertheless, that deserves and needs to be respected on its own terms.